Friday, July 21st, 2023. The court. Good morning. Good morning, Mr. Wright. Mr. Wright. Good morning. John Wright I'm here for the provincial crown. The court. Thank you. Mr. Freedom. Good morning, Your Honor. For the record, Dave Freedom. The court. Good morning, Mr. Freedom. Mr. Freedom, FREDM, first initial D, acting as Mackenzie friend for Mr. Carr. The court. Sorry? Mr. Freedom, acting as Mackenzie friend for Mr. Carr with the court's permission. The court. Are you acting as amicus? Is that? Mr. Freedom, Mackenzie friend. The court. What's a Mackenzie friend? Mr. Freedom is someone who would provide assistance to speak forth if Your Honor allows it. The court. I have no issue with it. Mr. Wright? I've never heard of that term, Mackenzie friend, before. Is that a case? Mr. Wright. I guess so. I've heard from Mr. Freedom before. I don't have an issue, Mr. Carr. As I understand it, is self-represented. The court. Yeah. Mr. Wright. I'm not taking a position with respect to the Mackenzie friend issue, Your Honor. The court. Yeah. Mr. Wright. I'm not really too concerned with that either way. The court. Okay. All right. That's fine. Mr. Freedom, if it's helpful, I've been in front of probably a dozen different judges and they've all been. The court, including me. Mr. Freedom. Yes. The court. But I just don't remember that phrase, the Mackenzie friend. That's fine. Mr. Carr. You're going to make submissions on your own this morning, and Mr. Freedom is going to make submissions as well. Is that right? Byron Carr. That's correct, Your Honor. The court. Okay. Thank you. Can you see me okay? Byron Carr. Yes, Your Honor. The court. Perfect. All right. So, Mr. Carr, did you want to begin then? Or, Mr. Freedom, are you going to be? Mr. Wright. Yeah. I can just, Your Honor, just before we get into submissions, I don't know if Your Honor wants a background. This is a defense application. I'd be seeking to cross-examine Mr. Carr on his affidavit. The court. Okay. Mr. Wright, there is an issue with respect to materials. I'll just raise that point. Your Honor has some of the transcripts on case lines. When this matter was set, if I remember correctly, on July 24th, yeah. No. It would be the 14th, I guess. There was an indication from Mr. Carr he wouldn't be providing transcripts due to financial barriers. I've made efforts to get transcripts. I've provided some of them through case lines. Your Honor will have the bail review. Decision of Justice Maranger, written decision of Justice Maranger, and the original bail decision of Justice of the Peace Logue. Those are all on case lines. I've made an effort to get the original transcript of the hearing at bail review. I've not been able to get that at this point. I'm content to proceed. That being said, I do have some concerns. I'd like the evidentiary record to be complete. Again, I'm prepared to proceed today. Obviously, Your Honor can make a decision about whatever evidence Your Honor needs to make a decision on whatever issues. But if Your Honor is, and from my position, seriously considering granting the application, ultimately, I'd ask for permission to continue to make efforts to get that transcript. I would do that in the future too. Provide that to Your Honor at a later date. The court. Before I give my decision? Mr. Wright. That's what I would ask, Your Honor. The court. Well, how long is it going to take? Mr. Wright. Well, again, it wasn't possible to do within the last week. Transcript process can take a variable amount of time, usually a week to 2 weeks, so I can only indicate I would undertake to provide that to Your Honor, but my position is it's an important foundational piece to the application. And again, I'm undertaking to provide that. It's normally the applicant's responsibility, but again, I'm doing that out of consideration for the various barriers in play, as it were. The court. All right. Go ahead, Mr. Carr. Mr. Freedom. I'll be making submissions, Your Honor. The court. Okay. Mr. Freedom. Again, for the record, Dave Freedom. FREDM, first initial D. So as you can see, Your Honor, there are quite a few people watching today on the Zoom. The court, should we repeat the Zoom warning if we have not already done so? Clerk Registrar, I can, Your Honor. The court, yeah. Thanks, Mr. Freedom. Clerk Registrar, thank you. You are not permitted to make any recording of the proceedings or take photos or screen captures of the proceedings. It is an offense under Section 136 of the Courts of Justice Act, and it may constitute contempt of court for anyone to copy, record, screenshot, photograph, publish, or broadcast a court hearing or any portion of it, or otherwise disseminate such a record, including on social media and/or other internet sites without express permission of the court. Thank you, Your Honor. The court, go ahead, Mr. Freedom. Mr. Freedom, thank you, Your Honor. It kind of worked out that I said that because I was actually going to say that there's a lot of people watching, because many have a vested. Clerk Registrar, sorry, Your Honor. I'll mute them. The court, mute them all. Clerk Registrar, yeah. Mr. Freedom, you can do that, right? I'll mute? Okay. Perfect. Clerk Registrar, yes. Mr. Freedom, so yes, as I was saying that, as you can see, there are many people watching. I think it was 32, probably going to be rising more than that soon. That's because many people do have a vested interest in what happens today to Mr. Carr's bail. Freedom of speech has always been my favorite right because without it, you can't exercise all the other rights. It's no secret that some people have lost faith in the system, especially after seeing images of violence towards peaceful protesters and bank accounts frozen. Good people with no records being imprisoned arbitrarily and intentionally silenced for speaking up. And I have a confession to make. As optimistic as I am, I wondered how long we wait until we see a win for civil liberties. Post-freedom convoy. And then came along our V. Blanchfield. And the May 8th decision essentially restored another protester's rights to freedom of speech, something that should have never been taken away in the first place, and the ruling, no doubt, stopped government overreach in its tracks. For some here today, it may feel like a bit of a déjà vu because it was just 3 months ago I was arguing for the same right for Mr. Blanchfield. What's important to note, why I mention that is, Mr. Blanchfield was just as much an active and peaceful, lawful protester in the Freedom Convoy as he was in Rolling Thunder. Very important to note that the Crown may not know that information as well. So if I go on, I'm not going to read everything in the factum, obviously, but just go through some of the points. I'll be covering violation of freedom of speech, which is germane to any democratic society. Unreasonable bail conditions that violate the Canadian Bill of Rights, the finding of reasonable bail, no chance for conviction. The Canadian Bill of Rights has constitutional authority and bail conditions are disproportionate to the alleged crime, especially now that we've seen that 2 charges have dropped and we're simply facing summary offenses. Mr. Carr is asking the court remove the social media bail condition. In the alternative, in spite of the fact that Mr. Carr has never incited people to break the law, a variance of this condition can be initiated as follows if the court sees fit. We'd be fine with does not use social media or any other modes of communication to counsel others to break the law. And that goes without saying. On February 19, 2022, Mr. Carr peacefully and lawfully exercised his rights, protected under the Canadian Bill of Rights of Free Speech Section 1D and Assembly 1E in the city of Ottawa with a protest against the federal vaccine mandate for travel. At no time did Mr. Carr breach the peace or break the law in any manner, nor did Mr. Carr have a history of law-breaking whatsoever. And on February 19th, after being arrested and physically beaten, Mr. Carr was taken to jail and processed where he spent 41 days in inhumane conditions with a total of 40 minutes of sunshine. Now between March, just to give some history in terms of the bail side we're talking about. Between March and June, there was some relaxation of the conditions, but as Your Honor can see, the Crown seems fixated on silencing Mr. Carr, specifically on politically charged and things that are usually up for debate and fiery conversations today. Let me go down here. If we look at, so the issues and laws, so why freedom of speech is freedom of speech in general, as we all know, is germane any free democratic society. If you look at things like the Courts of Justice Act, specifically 137.1, it talks about the purpose of the section. So I'll just read a few things here, which I think rings pretty true. A. To encourage individuals to express themselves on matters of public interest. This is B. To promote broad participation in debates on matters in public interest. And C. To discourage the use of litigation as a means of unduly limiting expression on a matter of public interest. And lastly, to reduce the risk that participation by the public in debates on matters of public interest will be hampered by fear of legal action. To apply restrictions on freedom of expression, whether verbal, nonverbal, goes against the presumption of innocence. The Courts of Justice Act 137 encourages free expression and discourages the use of litigation to limit expression on matters of public interest. Next section I'll discuss here is the bail conditions violate the Canadian Bill of Rights. Mr. Carr's current bail conditions unreasonably violate freedom of speech protected under 1D of the Canadian Bill of Rights. The illegal invocation of the Emergencies Act was gravely unjustified and unlawful as it restricted Canadians' freedom of speech, association, and peaceful assembly guaranteed under the Canadian Bill of Rights. This part I'm going to be talking about. No chance for conviction. On February 7, 2022, Justice Hugh McLean, Ontario Court, Superior Court granted an interim injunction seeking to silence horn honking, which he was successful at. However, what is important to note is that he wrote the following. This court orders that, provided the terms of this order are complied with, the defendants and other persons remain at liberty to engage in a peaceful, lawful, and safe protest. Justice McLean saw the protest as peaceful and lawful because that's exactly how he described it. The judge also used the words, remain at liberty, as in the defendants and others may continue to engage in peaceful and lawful safe protests. The preamble of the Emergencies Act. I call this, actually the elephant in the room, Your Honor. A lot of people don't talk about this, but the preamble says, whereas a governor in council, in taking such special temporary measures, would be subject to the Canadian Charter of Rights and Freedoms and my favorite, Canadian Bill of Rights, and must regard to the International Covenant on Civil and Political Rights, particularly with respect to those fundamental rights that are not to be limited or abridged even in a national emergency. And of course, Canadian Bill of Rights, it is hereby recognized and clear that in Canada, we exist and shall continue to exist. The following human rights and fundamental freedoms, namely freedom of speech, freedom of assembly, and association. Point 4 of the Emergencies Act. Is only to be invoked if the police are unable to deal with the situation under the existing criminal justice system. Former Commissioner of the RCMP, Brenda Lucki, made it clear that the government and the police had not yet used all the tools and the resources available to them. As well, RCMP, OP, and OPS all reported under oath to the Senate Committee and the Public Order Emergency Commission that they did not request the federal government to invoke the EA, the necessary evidence to invoke the Emergencies Act required by Section 3 was not given. Director Vigneault, to size, said the convoy did not qualify as a threat to security of Canada as defined by Section 2 of the Size Act, and that size cannot investigate actively constituting law protests. A broader definition of threats of the security of Canada is not legal grounds for invoking the EA. Part 2, Section 16 of the Emergencies Act lays out the requirements for the invocation of a public order emergency. The same section also states, threats to security of Canada has the meaning assigned by Section 2 of the Canadian Security Intelligence Services Act. Paragraph 3 of the EA prohibits violation of fundamental rights, even in a national emergency. Point 8. The rights of peaceful protesters were severely violated, contrary to the prohibition, freedom of speech, assembly, and association. The right to protection from arbitrary treatment by police were violated because, for no reason, the protesters were beaten and their property damaged and confiscated, and they were arrested without cause, and many, like Mr. Carr, stayed in jail. without reasonable bail. As per Section 17.1 of the Emergencies Act, it actually reads, when the governor and council believes, on reasonable grounds, that a public order emergency exists and necessitates the taking of special temporary measures for dealing with an emergency, the governor and council, after such consultation as is required by Section 25, may proclamation so declare. The clause I just read makes it clear that the only party permitted to declare an emergency is the governor and council. Mr. Trudeau is not the governor and council, as is made up of 39 cabinet members. He declared the emergency himself, as we learned under oath, from the public inquiry. And, public inquiry from 2002 under Public Order Emergency Volume 1. And that, of course, states, Cabinet met at 8:30 p.m. that evening, after receiving a situational update and a briefing on the Emergencies Act. Cabinet proceeded to deliberate on whether the threshold had been met and the Act should be invoked. The consensus was that it should be, and the First Minister's meeting should be called to consult with the provinces. The final decision on invoking the Act was left ad referendum to the Prime Minister, following the First Minister's meeting, meaning that no further cabinet meeting would be necessary. The proper procedure as per Section 17 and 25 of the EA would consist of A. Consult the provinces, B. Meet and vote and declare the emergency. What actually happened was Cabinet met and gave a consensus supporting the invocation before the provinces were consulted, and B. And Mr. Trudeau consults the provinces and declares the emergency himself. And, of course, we can look at again Section 25.1 of the EA. And again, I realize, Your Honor, this type of stuff obviously is more for trial and potentially constitutional questions that we would pose later on. But this goes along with, of course, what we're talking about in terms of the conviction side. The Crown overall has provided no information nor evidence that the defendant did behave unlawfully, causing mischief and obstructing police. So if we look at, for example, Ottawa Police Service Charge Sheet, mischief, Criminal Code 430(1)(c) defines that every one commits mischief who willfully obstructs, interrupts, or interferes with the lawful use, enjoyment, or operation of property. So disclosure says the following, just a little blurb here. On February 19th at 411 hours, 1,141 hours, the accused, Byron Carr of Edmonton, Alberta, knowing that there was an order in council in place and knowing police warned all protesters of the Freedom Convoy demonstration to leave the area, bound by 417 Booth Street, Ottawa River, and the Rideau River, in the Ottawa of Wellington Street and Metcalfe Street, and refused to abide by the police orders, demands to leave the area. That's from disclosure. We would say there is no evidence provided in all the disclosure documents that Mr. Carr willfully interfered with the lawful use of property. In fact, he makes his intentions very clear by stating the following, per the link I've attached, labeled as Exhibit 1, where he states, there's enough room for a semi to get through and emergency vehicles, because we won't block off an emergency access lane. We will leave it open for service vehicles that need to get through, first responders, fire. Timestamp at 5:10 minutes. Common law defines the criteria the police need to have in order to violate civil liberties to keep the peace according to Fleming v. Ontario 2019. And these authorities make clear an act that can be considered a breach of the peace only if it involves some level of violence and a risk of harm is only in the face of such serious danger that the state has the ability to lawfully interfere with individual liberty comes into play. Behavior that is merely disruptive, annoying, or unruly is not a breach of the peace. The Supreme Court has also ruled that streets are clearly areas of public concourse where expression of many varieties has long been accepted. Reference Montreal City versus Quebec Incorporated. And if we look at the other charge, because there's the two remaining charges now, the Ottawa Service Police sheet states, a violation of Section 129A of the Criminal Code, where everyone who resists or willfully obstructs a public officer or peace officer in the execution of their duty, or any person lawfully acting in the aid of such an officer. Disclosure states the accused disobeyed a court order in counsel, and obstructed the public order officers in the execution of their duties. Aside from several reasons why the Emergencies Act was illegally invoked, already mentioned, the EA's preamble states very clearly that it shall not violate the Canadian Bill of Rights, namely freedom of assembly and association and freedom of speech. And, of course, Section D, bail conditions are would extremely disproportionate to the alleged crime, again, emphasizing summary offense. We look at R. V. Skelly. Line 29, my duty is to balance Mr. Skelly's right to freedom of expression with a prohibition to use social media to break the law. Line 30, thus, Mr. Skelly is free to use social media for ordinary purposes, including for the purpose of expressing his political views or advertising his business. Justice Goldstein found that there was an error in law for the justice of the peace to have agreed to such a broad condition. And, of course, my favorite, I've actually framed this one because of my involvement. R. V. Blanchfield, May 8, 2023. And page 4, included in the statement by Justice Perkins McVeigh, we are allowed to express our political views. I don't mean we as in me, but we, as a society. Justice London Weinstein noticed the noted. Sorry, the following statement by Justice Corey in the Edmonton Journal. It is difficult to imagine a guaranteed right more important to a democratic society than freedom of expression. Indeed, a democracy cannot exist without freedom freedom to express new ideas and put forward opinions about the functioning of public institutions. The concept of free and uninhabited speech parameters all truly democratic societies and institutions. The vital importance of the concept cannot be overemphasized. Mr. Carr did not break the law. This is separate. This is what we're saying now, of course. End quote. Mr. Carr did not break the law, nor he intends to break the law or encourage others to do so. This will remain the case with or without social media ban. However, with the media ban, Mr. Carr loses his freedom of speech to criticize the government. And of course, I attached another case law there, Bracken versus Fort Erie, where it says just a quick line here. Finally, on a comparative analysis, the statutory and deleterious effects of the town's actions, the effects on Mr. Bracken were disproportionate to any benefit that was achieved. And in a free and democratic society, citizens are not to be handcuffed and removed from public space traditionally used for expression of a dissent because of the discomfort their protest causes. And of course, the case law we're relying on in addition to R. V. Skelly, R. V. Blanchfield would also be R. V. Zora, where it discusses it protects and accused persons from unreasonable terms and conditions of bail. Also R. V. Antic, where it discusses that the terms should only be imposed to the extent that they are necessary to address concerns related to the statutory criteria for detention and to ensure that the accused is released. This part's important. They must not be imposed to change an accused person's behavior or punish an accused person. And Antic also held that the courts should exercise restraint when crafting bail conditions in common. Law makes it clear that bail conditions must be tailored to the individual risk posed by the accused. The conditions must address the crime the accused is charged with. Of course, so the error in law is placing the restrictions on freedom of speech from Mr. Carr's charges were unrelated to the internet use, making the bail conditions unreasonable and, of course, change in circumstances. Stems from the fact that the Freedom Convoy occurred 1.5 years ago. I won't go over all this stuff, of course. This is just extra case law I'm going to put in the factum. Talks about the Canadian Bill of Rights has constitutional authority. As per Section 26 of the Charter, you can't use any previous legislation. And of course, these are all post-Bill of Rights case laws, post-1982, of course, that I've attached, that have been used. And of course, because we're dealing with criminal, it would only be federal, so it can be applied. Let me just see here. Okay, I think just one thing more I want to do here. I'm just going to take a quick sip of water, Your Honor. Sorry. The court. Sure. Mr. Freedom. So we also received the Crown's response a couple days ago from Mr. Wright. And, I'm going to do something here maybe not necessarily conventional that a typical lawyer would do, or maybe not. I don't know. But I'm going to go through the response that he wrote and basically explain why every point is either irrelevant or just completely wrong. He makes a note that the number 1 point, the Crown is opposed to the application for the bail. Of course, he wouldn't be doing his job if he wasn't opposed to it. Point 2. The applicant is charged with mischief contrary to Section 430C, obstructing a peace officer contrary to Section 129 of the Criminal Code, Freedom Convoy demonstration, which took place between January and February. Mischief stems from this interaction with police on Metcalfe and Wellington. They made that clear in disclosure, where he did not block the traffic flow, and he made sure cars could get through, which you can see on the video. As far as the obstruction charge, Mr. Carr had every right to peacefully protest as per the preamble of the Emergencies Act stating that the Bill of Rights must be abided by. Point 3. In the Crown's response, on February 20th, the applicant was detained at a reverse onus bail hearing. He agrees with that fact. Point 4. Actually, I'll just skip the ones that of course, he agrees with some points. Mr. Carr agrees. He was detained for 41 days. Mr. Carr agrees with that fact obviously. As I mentioned, 40 days of yard time the entire time. The applicant was released by Justice Maranger with various conditions. He agrees with that. The Crown has consented to a number of variations of conditions including surety change, a change in address, and significantly to the bail review. The social media condition was varied as do not post or cause anyone else to post on social media of any type about Freedom Convoy, COVID-19 mask or vaccine mandate or anti-vaccine cause. This includes Facebook, Instagram, YouTube, and Twitter. That's not the definition of silencing someone. I don't know what is. While Mr. Carr appreciates the relaxation of the conditions, this is still a significant violation of freedom of speech. Bail conditions are normally set to try and reduce the possibility of reoffense. Speaking about COVID restrictions and peaceful protests or politically charged topics is not an offense. The applicant, this is now, of course. The Crown says the applicant brings a bail review. I'll skip that because he already agrees with that. Point 11 in the Crown's response. The Crown's position is that the facts of this case are distinguishable in the secondary ground. Concerns are closely linked to the applicant's use of social media. The Crown has already taken extensive steps to accommodate the applicant's legitimate use of social media. Further, variation of Mr. Carr's conditions would only provide an opportunity for Mr. Carr to commit further offenses in a matter that could prove difficult to investigate and prosecute. The significant risk of reoffending is exacerbated by the applicant's lack of understanding of what actually constitute criminal offense versus lawful protest. I would say his offense, again, has nothing to do with his involvement on the internet. For example, he was not charged with indiscernible mischief or libel comments about COVID-19 mandates or anything else in relation to social media. When the Crown states things like, Mr. Carr doesn't understand the difference between criminal offense and lawful protest, it's the Crown that doesn't understand that this is a debate for trial. My current variance of the applicant's condition not only raises a secondary ground. The Crown is saying this, of course. Point 12. Any further variance of the applicant's conditions not only raises the secondary grounds for unattainable levels, but also puts both the applicant and his sureties at risk. Let me remind the Crown again that these charges have nothing to do with the internet. And, of course, if we look at the case laws he provided. Let me just go back here. We would argue, obviously, and again, taking a look at R. v. Skelly and R. v. Blanchfield. These are decisions that have been made in court, not necessarily to do with bail conditions. So the Crown states also that the applicant was initially detained by Justice of the Peace and released on the bail review following the material change in circumstances involving a more substantial and Comprehensive release plan. What we're saying is Mr. Carr wanted to get out of jail and was willing to sign anything to do so, especially with the inhumane conditions. There's actually quite a bit of case law on this as well. Inferentially, the applicant was. This is the Crown, of course. The applicant was released on the least erroneous conditions possible at the time, whereas not for the restrictions of the applicant's social media. The applicant would have remained in custody. Can't believe that one. Again, what does his use of social media have anything to do with his alleged summary offenses? If these are such heinous crimes and the need for the most serious form of bail conditions, why did the Crown offer Mr. Carr a 6-month probation for pleading guilty on all 4 charges? The Crown's position, this is what the Crown says, is that the applicant is no longer indiscernible to abide by restrictions on his social media and should be returned to custody. To be quite honest, I can't believe I just read that, especially for someone who is, again, being charged for 2 summary offenses and who poses no risk or harm to the public. That's more of a statement for murderers or pedophiles, I would suggest. Point 17. Since the time of the applicant's release, this is what the Crown is saying. Of course, the Crown has consented to the various requests to vary the applicant's conditions. We're saying, of course, this was done acknowledging the applicant has abided by his conditions so far and to address specific concerns raised by Mr. Carr in terms of his ability to communicate with members of this community and his ability to carry out his employment. The Crown has clearly acknowledged that Mr. Carr is not at risk by breaching his conditions by saying, of course, he has not breached them thus far, and there is no reason to be hypervigilant with the bail conditions itself. 18. The condition, this is what the Crown is saying, of course. The condition restricting the applicant's social medias is connected to the manner in which Mr. Carr is alleged to have committed offenses. Again, there are no charges or allegations that involve social media. 19. The condition, this is what the Crown is saying. The condition is currently awarded is not a blanket ban on the social media. It is extremely targeted and specific. I guess that's their justification for the not talking about politically charged issues. It seems to me that the Crown is clearly taking a political stance on this matter of interest with this use and is nothing more than censorship and punishment through the process. Point 20. The Crown says, Mr. Carr, during the Freedom Convoy, not only documented evidence of his own involvement in the massive interference of enjoyment of property, but also used his social media to create a platform for various leaders of the Freedom Convoy. My position here would be that the Crown is politicizing here again. It is not the Crown's job to censor information on the internet on behalf of the government. Point 19. The Crown also says that Mr. Carr could be described as a middle management of the convoy or a go-to-between leadership and other participants in the Freedom Convoy. Again, what does this have to do with the charges of bail? 22. The Crown says that the stage of the impact of the Freedom Convoy has been subject to public commission and various Ontario Court of Justice decisions. And, of course, they state again, different case laws. So are v. Rimouski, R. v. Dakar, and so forth. And again, we would counteract that obviously with the most recent decision, which is R. v. Blanchfield, and of course, Skelly, and of course our submissions. I think I'm almost finished here. Give me 1 second. Sorry. Yeah. And of course, if we just go back. So we go back to the Crown's conclusion, they say that in certain cases, it may very well be sufficient to indicate in accused persons that they are to obey the law. The kind of condition becomes useless, however, when an accused person doesn't know or is willfully blind with respect to what the law is. Our conclusion on that would be that these charges have nothing to do with the internet, and thus these restrictions on freedom of speech are unreasonable and unnecessary. The other point, and I would also end it by that in a democratic society, we have a long-standing history of freedom of speech. Every citizen has the right to participate in peaceful protest, and have already gone through the era in law and change in circumstance. I think I'm almost completed here. Yes. And of course, I'd probably just end it with my favorite quote from John Diefenbaker, creator of the Canadian Bill of Rights 1960, when he says, "I am a Canadian, a free Canadian, free to speak without fear, free to worship God in my own way, free to stand what I think right, free to oppose what I believe wrong, free to choose those govern my country. This heritage of freedom I pledge to uphold for myself and all mankind." Those are my submissions, Your Honor. The Court, thank you very much. Mr. Freedom, thank you, Your Honor. The Court, Mr. Wright? Mr. Wright, so as I indicated at the outset, I'm seeking to cross-examine Mr. Carr on his affidavit. That's how I propose to proceed next. The Court, thank you. Mr. Freedom, Your Honor, can I take a 5-minute recess just to answer that if we would feel, if you feel comfortable at this point, to do that? The Court, sure. Mr. Freedom, if you don't mind? Thank you, Your Honor. Appreciate that. The Court, we'll take a 10-minute break. I'll just step outside. Mr. Freedom, 10 minutes? Okay. Thank you, Your Honor. The Court, do I have a copy of Mr. Carr's affidavit? Yes, I think I do. Mr. Freedom, I have an extra if you'd like. The Court, so, Mr. Carr, you're not to the Crown, is not permitted to ask you any questions about the actual offense itself. So when you're being cross-examined on your affidavit, you're not to talk about the offenses that are before the Court. All right? Byron Carr, yes, ma'am. The Court, because the Crown does not have the ability to do that, and I won't permit it. So I don't want you voluntarily launching into a discussion of the offenses that are going to be tried by the trial judge. Okay? Byron Carr, yes, Your Honor. The Court, thank you. Let me know when you're ready. Mr. Freedom, Your Honor, with just a quick preliminary, with the Court's permission, she's not going to say anything, but could she sit beside me just to take notes? Would that be okay? M.S. Garf, Ph. The Court, who is Ms. Garf? Mr. Freedom, just an assistant to me for taking notes. The Court, no. I would prefer that you sit in the body of the Court and you can take notes. Mr. Freedom, okay. Understood. The Court, you can sit in the front row. Okay. Mr. Freedom, yeah. Okay. Thank you, Your Honor. The Court, yeah. You can sit right in this front row. You don't need to sit behind the dock. If it's easier for you to hear, you can sit right behind Mr. Freedom there, and that chair is fine. All right. So let's have Mr. Carr sworn or affirmed so that he can give evidence. Clerk Registrar, yes, Your Honor. Mr. Carr, please state your name in full for the record and spell your first and last name. Byron Carr, Byroncrr. Byron Carr, affirmed. The Court, thank you. Clerk Registrar, thank you. The Court, go ahead, Mr. Wright. Mr. Wright, thank you, Your Honor. May I remain seated just for purposes of Zoom? The Court, all right. M.R. Right. I'm happy to stand as well, but it's a less flattering angle, frankly, from my video. Q. Mr. Carr, can you hear me okay? I can hear you. If you guys are able to adjust your volume up a little bit, I have mine maxed. Q. Just going to move over. Can you hear me? Better now, Mr. Carr? Yes. Q. Okay. So, Mr. Carr, I'll just have a few questions for you. Again, Her Honor warned you, I'm not allowed to ask you about anything to do with the offenses themselves. And I'll just sort of outline where I'm going with this. I'm going to be asking you about your understanding of the law. And that's all perspective going forward. That has nothing to do with anything that happened in the past. Okay? Okay. Q. So if I'm going to be asking you a question, essentially a hypothetical, and if you're thinking to yourself the answer is that's not what I did, or that is what I did, that's not the right answer. Okay? I'm not asking about what happened in the past. Okay? So again, I'm going to describe a situation to you, and I'd just like you to indicate to me if and when you think this is probably illegal. Okay? And again, in fairness, what we are dealing with here and what we're dealing with generally is the boundary between legal protest and criminal conduct. And again, no one's expecting you to, provide a dictionary definition here or anything like that. Again, I'm just interested in your perspective of what the boundary is where things cross over to probably illegal. Okay. Is that all clear? A. That is clear. Q. Okay. So again, I'm going to describe a situation. If we can imagine a city, and it doesn't matter which city, it's a city in Canada, and we'll say it's about 1 million people. There's a downtown area. And Mr. Freedom, objection, Your Honor. We would much prefer to keep this refined to the actual affidavit itself instead of a hypothetical. I don't see how this is relevant. If he wants to question Mr. Carr on the affidavit itself, we have no problem with that. I know where this is going, and then I don't agree with it, of course. The court. I have a concern that it touches on the offenses before the court. Maybe you're framing it as a hypothetical, but you're going to ask him to opine as to whether or not what he's alleged to have done is legal or illegal. And I'm not comfortable with that, Mr. Wright. Mr. Wright. So no. Respectfully, Your Honor, my position is that it's a different situation. Again, Mr. Carr is free to say at trial, no. I don't agree with the general perception of the Freedom Convoy was. We weren't blocking streets. He can have that as a defense. That's fine. He can also say I'm not responsible for the overall impact of the Freedom Convoy. That's been a defense that's been deployed and used successfully in some cases. What's at issue here with respect to the bail review is that Mr. Carr is proposing specifically a condition that he not break the law or not encourage other people to break the law over the internet. To be enforceable, Mr. Carr has to have a vague idea of what the law is. I think it's going to become abundantly clear that he doesn't understand that, and I think I'm entitled to explore that. Again, I've made it very clear that I'm not asking him to explain what happened. I'm asking his perception on legality. Now, again, these are generally questions that aren't asked in a bail review, bail hearing context. In my submission, that's because the answers are so easy. If you ask someone who's accused of drug dealing, sir, do you plan on drug dealing in the future? Do you understand that drug dealing is illegal? The answer is clearly going to be no. Or at least, the person is going to say no, I'm not going to drug deal in the future. Of course I understand that that's illegal. I'm not sure if that's going to be the case here, Your Honor. And I think I'm entitled to explore that. Those are my submissions. The court. Well, I think that my concern is that they're going to prejudice Mr. Carr at his trial because they're too close to the allegations which are before the court, and I'm not going to permit you to ask those questions, Mr. Wright. You can move on. You can ask him about his social media usage and that, the things that relate to the variation, if you have questions in relation to that. Mr. Wright. Thank you, Your Honor. The court. Yeah. Mr. Wright. Q. Mr. Carr, if you're granted the variation, well, let me ask this first. You understand the variation now that's already been granted has allowed you essentially to participate on social media to any extent you've raised concerns in the past about communicating with members of your community. You're allowed to do that now, correct? I'm allowed to do that. I have a quick question for that. I am a very proud Métis man, recognized one of 3 original Canadians, one of 3 original habitants in Canada, First Nation, Métis, and Inuit. You've taken me out of my community. You've blatantly put these restrictions, denying me access to talk to my elders, to my community. And with all due respect, everything falls under freedom of being able to talk to our elders. My whole generation and bloodline is that of defending our freedoms and rights. And you silenced me. Q. Okay. So again, generally, I'm going to be asking questions. You understand I didn't impose any conditions on you, right? I understand what the job is of the Crown. Q. Okay. To prosecute. Yes. Q. Okay. You understand what happened at a bail review, correct? I understand that I was denied my Indigenous heritage by indiscernible that straight out refused that I was of Métis descent where I spent time incarcerated, furthermore, in OCC. And then they denied the fact that when I had my presidents and my family members stand up to actually say Mr. Carr is of indigenous descent, that they didn't want to contest the fact, and then I was granted bail by Judge Maranger. Q. Right. And you understand there's a difference, right, between when the Crown takes a position and when a judge imposes an order or condition. A. Sorry. Can you repeat that? Q. Yeah, that wasn't super clear. You understand there's a difference between the Crown's role and a judge's role? A. I do. Yes. Q. The condition as it stands, do not post or cause anyone else to post on social media of any type about the Freedom Convoy, COVID-19 mask or vaccine mandates, or the anti-vaccine cause. This includes Facebook, Instagram, YouTube, and Twitter. That's the condition that you're currently restricted to in terms of your social media. Correct? A. That's correct. Q. Okay. And that doesn't impact your ability to work or go to school or anything like that? A. It does impact every aspect of my life. Q. Okay. How does it impact that? Your ability to work or go to school? A. A lot of the people that I talk to in my community are heavily rooted in Canadian Bill of Rights. Our freedoms are everything, especially Indigenous rights. Q. So how has that prevented you from working, your ability to not post about those items? A. Well, these charges that I face, if I wasn't Indigenous, I wouldn't be able to continue with my work. The fact that I am Indigenous, I travel under the J Treaty Act into the United States and applicable other countries that recognize Indigenous rights and sovereignty and freedom of speech. As per being at work in Canada, while I'm very limited on who I can interact with, seeing as how it wasn't a small, indiscernible minority that attended to come down to Ottawa as the most of Canada decided to go down to Ottawa to address these issues. It's taken me out of my community a great deal. Q. So what specific with respect to that condition has stopped you from working? A. Sorry. Pardon me, sir? Q. Did you hear the question when I asked it the first time? What is it about that condition that has prevented you from working? A. The conditions that were drawn, the just obey Attorney General that was frowned upon, that was relaxed, and Judge Boxall had renewed those conditions. Those did prevent me from taking some jobs. Q. Okay. So, Mr. Carr, you understood my question, right? I was asking about the specific condition, do not post or cause anyone else to post on social media of any type about the Freedom Convoy, COVID-19 mask or vaccine mandates or the anti-vaccine cause. This includes Facebook, Instagram, YouTube, and Twitter. You said that was affecting your ability to work. Is that still your position? A. It did affect my ability to work. Yes. Q. In what way? A. The fact that I couldn't properly communicate with people around me. Q. So. A. With my peers, with my colleagues, with anybody. In Canada, basically. Q. Where are you employed, sir? Oh. I'm employed in Calgary, Alberta. Q. In what field? A. Oil and gas industry. Q. Okay. And that's the work you currently do? A. In the oil and gas industry. Yes, sir. Q. Okay. And how if you shut down your Facebook? And you shut down your Instagram, and you didn't post on YouTube and Twitter at all? Again, that's not the condition. But are you saying you wouldn't be able to work if you didn't have those applications? A. I'm a pretty resourceful guy and pretty handy. I'll always be able to work. But it did limit my ability to accept certain jobs and to do certain things. Yes. Q. Okay. Which job? A. Well, in the oil and gas industry. If I wasn't able to travel under the J Treaty Act, I wouldn't have been able to access other jobs within my company that sends me all over the country to work. The court, that wasn't the question, Mr. Carr. Really, what Mr. Wright wants to know, and there may not be an answer, is how this social media ban, right, which is only a ban, you're allowed to use social media, You're just not allowed to talk about the Freedom Convoy, COVID-19, COVID-19 mask or vaccine mandates, or the anti-vaccine cause, how that prohibition impacted your ability to work. That's the question. That the ability to travel under the J Treaty, that's a separate issue. Like those are other conditions that might have prevented you from working. But really, how did the social media, that particular ban, impact your ability to work? That's what he wants to know, if it did. Well, I'll use this as an example. Going out to meet other individuals on our work platform that have different ideologies. And when I had to blatantly ask if they were involved or partake in any COVID-19 mandates or freedom movements, they said yes. Therefore, I wasn't allowed to talk to them or communicate with them. The court, okay. And it's very difficult when you're supposed to be in clear communication with your colleagues and stuff, and you have to remove yourself. That itself had impeded my ability to work effectively with my colleagues. They're removing me from certain jobs that I was able to do. The court, thank you. MR, right, Q. So again, Mr. Carr, you're speaking about a different condition, right? It's not like you were going to work and encountering people who were sympathetic to the Freedom Convoy cause or what have you, and your ability to post on social media wasn't affecting your ability to have an interaction with them face-to-face. Correct? Sorry. Could you repeat that, please, sir? Q. Right. So you're talking about a different condition, sir, right? Not the social media condition. Well, doesn't that expand into my personal life? Saying that I'm not allowed to discuss the vaccine and anti-COVID mandates and stuff, freedom movements on social media. It affects my personal life as well. I tend to meet someone in a work setting that has their own opinions on wanting to be free and wanting to use their freedom of speech. And whereas I can't because that puts me in direct trouble because aren't they one and the same? Social media to our personal interactions? There are words, right, that we're using and we're discussing with social media. Q. So let me be clear, sir. Again, the original question I had was about your ability to work, and you said it was affected by this specific condition, social media. And I'm going to suggest to you that there are plenty of people you probably work with who have no problem doing their jobs who probably don't have social media at all because just they're not interested in it. Is that fair to say or no? No. Q. There's not one person you work with who's not on social media. No. Q. Okay. Everyone's live tweeting all the time? I would have thought people would be a little bit busier in oil and gas industry. We people are very social creatures. Q. Right. So you're saying there's not one person. How many people do you work with? A lot. Q. Like how many? 100? Probably more than that. Yeah. Q. Okay. And there's not one person that you're aware of? Or do you think it's possible? I'll put it this way. Do you think it's possible that one of them doesn't have Twitter? I'm sure. I don't know if they have all platforms of social media, but I'm pretty sure all of them probably have at least one form of social media platform. Q. No one. Do you think it's even possible that someone? Mr. Freedom, Your Honor. Objection. What is Mr. Carr's opinion on whether or not people have social media or not have anything to do with what we're discussing? He's already answered the question about how he interacts with colleagues who have the same political views, which could mean that a simple comment from a work colleague could throw him in jail or even liking it. I mean, it's a gray area. Anyway, that's my objection. The court, I'm going to allow it. Go ahead, Mr. Wright. Mr. Wright, I think I'll move on, Your Honor. I think that the point's been made. MR. Right. Q. So, Mr. Carr, can I ask with respect to this trial, it's coming up in September, correct? Your trial, sir? Sorry. Can you repeat that? Q. Your trial is going to be in September? Yes. That's correct. Q. Okay. That's about 2 months away? Yes. Q. Okay. And can I ask, are you planning on Attending the trial personally, or would you bring in? Application to attend via Zoom? A. Oh, no. I fell in love with the city of Ottawa and definitely plan to go down to Ottawa. Q. Okay. Do you plan on encouraging other people to attend the city of Ottawa? The court. Don't answer that question, Mr. Carr. A. Indiscernible. The court. Mr. Carr, don't answer that question. You're touching on the offense, Mr. Wright. Mr. Right. If I can have a moment, Your Honor. The court. Certainly. Mr. Right. So again, I'll just raise this at this point. Again, I think I've made my position pretty clear. I've obviously heard Your Honor's decision with respect to the restrictions on my questioning. I'll just indicate that Mr. Carr's affidavit at paragraph 2 indicates, at no time did I breach the peace or break the law in any manner, nor do I have a history of law-breaking whatsoever. I was peaceful at all times during the protest. I did not engage in any illegal activity whatsoever, nor do I have any history of illegal activity whatsoever. My family, friends, and acquaintance can attest to my peaceful and lawful history. It goes on from there. The court. Mr. Wright, there's a couple other issues with respect to conditions of release and whatnot, or conditions of detention, excuse me. So I certainly respect, and I wasn't planning on asking Mr. Carr about the subject matter of the offense. I think it should be clear, however, if the affidavit is filed, there should be certain aspects to it. If I'm not permitted to question on it, it shouldn't be considered. The court. I agree. I'm not giving any weight to this number 2 where you're literally venturing right into the offense itself. So I take it that, Mr. Carr, you have no criminal record, sir? Byron Carr. No, ma'am. I do not. The court. All right. So I will take note of that. But other than that, I'm going to ignore paragraph 2. I think you're right, Mr. Wright. Mr. Right. And likewise, paragraph 4, Your Honor. The court. Yes. Mr. Wright. Again, there's reference to being arrested and being beaten. I'm asking that not be considered as well. And with those comments, Your Honor, I don't any other questions. The court. Thanks, Mr. Wright. I agree with you on that. Let's turn to your submissions now. Thank you, Mr. Carr. You stay with us now. Mr. Wright is going to make his submissions. Mr. Right. Thank you, Your Honor. Byron Carr. Yes, Your Honor. Mr. Right. And again, I won't be very long, Your Honor. Obviously, Your Honor has my written submissions, and they've frankly been explored in pretty detailed depth over the course of Mr. Freedom's discussion. I think one thing that was jumped over pretty quickly was the case law that I've provided. That was one thing we didn't go into in detail. And again, at the end of the day, Your Honor, this isn't a trial. At the end of the day, Mr. Carr is welcome to whatever submissions he may choose to make at trial. He's welcome to bring whatever defenses, whether they be charter, Bill of Rights issues, whatever the case may be. The issue at this stage is it's not controversial amongst reasonable people that the Freedom Convoy involved the imposition of an interference with the lawful enjoyment of property. We have a number of decisions now, and it's just not controversial. Your Honor's decision in Blanchfield was not dealing with the substance of the allegations, it was dealing with specific condition. The court. That's right. Mr. Right. The decisions that have dealt with, ultimately, the issues at trial, again which are somewhat secondary to this bail review, I think, clearly point in one direction, and everyone has the ability to recognize that or ignore that or argue for distinguishing features. That's completely fine, and that'll be left for the trial. But the concern here is at the end of the day, and I think this is clear from the materials provided in terms of what Mr. Carr has been posting on social media and what his participation in Freedom Convoy is clearly he does not understand the difference between lawful protest and criminal conduct. And to be fair, sometimes that can be a blurry line. I think that I've made reference to cases in Ottawa involving the blocking of street for an hour, and in one case that was considered to be protected under Section 2B, and ultimately, there wasn't a conviction in that case. I think it becomes a lot clearer when we're dealing. The court, there was or was not. Sorry, was or was not. Mr. Right, was not. The court, thank you. Mr. Right, right. So it's distinguished in what would be a binding case on the Ontario Court of Justice, with a case involving a roadblock for 2 days. And again, I think be excused for saying there's a fine line between those cases perhaps. I think it becomes a lot clearer when we're not talking about 2 days, we're not talking about 3 days, we're talking about multiple weeks. And again, it's a sort of bizarre situation. Your Honor, where, normally we be. Before Your Honor, there be no question as someone, again, to use Mr. Freedom's example, someone who was a pedophile, if they were, again, not to suggest that that's the case here. And there are levels of seriousness, not to suggest that this case is not serious, but obviously, they're on different levels. If someone in court came and indicated, look, I'll follow conditions, I'll obey the law, but just so, I think that having sex with children's okay. I think that's legal, but I won't break the law. Obviously, that's a situation where someone wouldn't get out of custody. Now I think in this situation when we're dealing with these conditions, it is a different situation and the court has to be sensitive to an individual's ability to engage with their community, to work, to engage with lawful activity online. The problem here is that there's not a recognition of what's illegal and legal. And the court may be tempted to say, well, I'll leave that for Mr. Carr and his sureties to find out. If there's an issue, and he'll be charged and he'll have to deal with that. In my respectful submission, it's not fair to Mr. Carr nor his sureties to indicate a condition like just don't encourage other people to break the law under these circumstances where there is this clear misunderstanding, because it puts Mr. Carr at risk. Perhaps more importantly, it puts his sureties at risk, who we've not heard from, and it's not clear whether they'd be supportive of this or if they have a similar understanding, if they'd have any ability to supervise that kind of a condition. So I think that's problematic, Your Honor. And I'd just ask Your Honor to consider again Justice Moranger's decision in context. Again, there may not be specific reference to the balancing. And ultimately, I take my Mr. Freedom's point that the situation has changed somewhat. And as situations evolve, the Crown has looked at that condition, which was initially a total ban on social media or amounted to that essentially. And that's been amended to allow for Mr. Carr to engage in lawful activities. The question is, where does that balancing act? Where is the appropriate middle ground in terms of respecting Mr. Carr's ability to engage with his community and not putting him in a situation where his conditions are overly vague and unenforceable? So that's the question, Your Honor. In my submission, the answer is fairly clear, and I think Mr. Carr has been treated extremely fairly in terms of these conditions and the amendments that have been granted. I'll leave it at that, Your Honor. But again, subject to my written submissions and my indication at the beginning of the day that again, if Your Honor is seriously considering amending this condition, I would ask Your Honor to consider the transcript of bail review. And the reasons for that, again, just for completeness of the record, but there's also a discussion in Justice Moranger's decision of the evidence of Mr. Carr at the bail review. And the assigned Crown at the bail review made the submission ultimately that Mr. Carr's evidence was devoid of credibility or words to that effect. Justice Moranger disagreed with that. His words were, Mr. Carr's evidence was subject to interpretation. Obviously, that's an important distinction. But, frankly, again, when judges say, Mr. Right, your submissions are subject to interpretation, it's not the most complimentary thing in the world. So I think that's a concern that's there. And frankly, we don't really know the extent of it so far. So that's why I'm taking that position. The court, when do you think we will realistically have that transcript? It could be an electronic format. I don't need it. I don't need a printed copy. Mr. Right, I can, again, I made efforts to get it for this week. I don't want to put a number on it, but I'd certainly make best efforts to get it as soon as possible. The court, Do you think it'll be here before next Friday? Mr. Wright, I think the chances would be likely. The court, okay. Mr. Wright, but again, I don't want to hold myself to that. The court, all right. Thank you, Mr. Wright. Mr. Right. Thank you. The court, I'll wait until I receive the transcript. Mr. Freedom, did you have anything that you wanted to add briefly? Mr. Freedom, yes. I won't be too long, I guess. Because submissions was, so Mr. Carr, I just want to point out, obviously, the obvious here is not the Freedom Convoy. I know that. Well, I won't get into other trials, but I noticed that. Seems to be a common theme that they will say what happens in a city and then one person takes the blame for it, but not looking at the individual and what the individual did, how they protested, etc. This is why, for example, Exhibit 1 shows him keeping a lane open and not blocking traffic. And you can see a car go through. And, of course, the submissions of the quotations I've put in, the factum about how he's being respectful to keeping flow of traffic, including the court, Mr. Freedom, I'm going to stop you there. Mr. Freedom, yeah. The court, you saw me repeatedly prevent Mr. Wright from cross-examining Mr. Carr about the offenses itself. So I'm not going to give weight to those submissions. Mr. Freedom, fair enough. Fair enough. The court, the issue for me is whether I can vary this bail. Mr. Freedom, yeah. The court, to allow Mr. Carr to have freedom of expression within the context of this case or not. That is the issue. Mr. Freedom, yeah. No. I understand that. Okay. Fair enough, Your Honor. I know we went into, of course, his Mr. Carr's understanding, I suppose, of what's the difference between a legal and illegal protest. The court, I didn't allow him to ask that question. Mr. Freedom, sure. Yeah, you're right. I would say that we have things in the criminal code that obviously prevent him from that can, obviously, get him trouble whether or not is the blocking of a highway, for example, which is in the criminal code. So there's many sections, of course, that he'd have to adhere to, and he's obviously mentally capable. He understands the law in this country. And again, I would say he's not facing a charge that has a direct tie to social media. It's also very odd that he can't talk about all topics but except, obviously, COVID-19 topics and those types of things. So I think that just makes it pretty obvious that there is a political stance here. Those are my submissions, Your Honor. The court, thank you. We will come back next Friday at 9 o'clock by Zoom for a decision if I have received the transcript. If I have not received the transcript and had time to review it, then I'll let counsel know, and we'll have to postpone it until the time that I do. All right? So 9 a.m. next Friday by Zoom. All right. That's just because I'm waiting for one transcript. Okay. Mr. Carr? Byron Carr. Yes, Your Honor. The court, okay. We'll see everybody next Friday at 9 o'clock if the transcript is received in time. And if not, then we'll adjourn it. Thank you. Mr. Freedom. Thank you, Your Honor. The court, have a good weekend.